Thank you very much for your presentation and your service. I was wondering, I know a lot of us, at least personally, I have questions regarding how the current military tribunal system is set up for detainees, how that differs from the argument that they should have access to federal courts. And personally, as someone who was down there, did you see that military tribunal process take place, and what were your comments on that?
Okay, great question. The question here is about the military tribunal process that is in place now to put prisoners on trial. One, I never witnessed any of that because they hadn't even gotten to the point to litigate any of that concern at that particular time. When I was there, it was completely the interpretation of the U.S. government that these prisoners are enemy combatants, that they don't have rights, not even under Geneva Convention. So they didn't have rights to lawyers, they didn't have rights to due process, they didn't have rights to contest anything about how they were being held in Guantanamo. After my time in Guantanamo, that actually went to the Supreme Court. And the first case ruled against the U.S. argument that this was in Guantanamo, not in U.S. soil, and therefore these prisoners have no rights to U.S. courts. Well, the Supreme Court ruled in Rasul v. Bush that no, Guantanamo was essentially completely controlled by the U.S. government, by the United States. Prisoners do have access to the courts. And that allowed now the process of lawyers to go down to Guantanamo and start to represent prisoners being held. The second Supreme Court decision was brought when President Bush tried to put these prisoners on trial. He came up with a tribunal process. Most people in the legal profession would say they were kangaroo courts designed to ensure guilty verdicts. Well, the Supreme Court ruled that this tribunal process did not meet the standards of international law, nor did they even meet the standards of U.S. military law. And they ruled that the president did not have the authority to put prisoners on trial in Guantanamo. So what happened next? President Bush said, well, I'm not giving up. I am going to get that authority. Who can he get that authority from? The U.S. Congress. So what he did was he took some legitimate terror suspects out of CIA black sites. There had been this report from the Washington Post that there were CIA black sites operating around the world, which our government had never admitted to. But in August of 2005, or 2005, I think it was 2005, President Bush would take some of these prisoners out of the CIA black sites and bring them to Guantanamo. 15 of the highest, to include Sheikh Khalid Mohammed and whatnot. And admitted that he had emptied out the CIA black sites, thereby President Bush admitting that we did have these CIA black sites. Brought them to Guantanamo. And that brought the support from Congress now to give President Bush the authority to hold tribunals in Guantanamo. And they passed what's known as the Military Commissions Act. This act gave the president the authority now to put prisoners on trial, but it also stripped the prisoners' habeas rights, meaning the right for the prisoner to contest anything about that prisoner's detention. Could not go to court to contest anything about why or how that person is being imprisoned. And that's a controversy today and will be the argument in the next Supreme Court decision, which is due out before June. Whether or not prisoners in Guantanamo actually have right to habeas, meaning they can go to court and say, this is unfair, how I'm being treated, how I'm being detained, how I'm being subjected to this lack of due process. But nevertheless, now there is this Military Commissions Act, which does have a trial process. But this trial process is not like U.S. military law. It's not like U.S. justice. It's a military system that allows for things like secret evidence, where the government can bring evidence against the prisoner and not even allow the prisoner to see that evidence. So if you have evidence that's in front of the prisoner, but he can't see it, how can that prisoner defend against that evidence if he's not allowed to see it? It's called secret evidence. The other thing that these courts allow are coerced evidence. There'll be some incidences where information which has been gained by quote, these enhanced interrogation techniques, or which human rights groups would consider torture, would be admissible in these courts. Would never be admissible in any other court here in the United States. And then finally, it also allows hearsay. A third person saying, well, I heard from so-and-so that this guy did this. It's called hearsay. Again, that's not admissible as evidence in our courts or in the military justice system, which I was subjected to. So again, most of the legal experts are saying this court system is guaranteed to bring about guilty verdicts, and that would harm our reputation in the world as being a nation that abides by the rule of law and undermining our ability to champion as being a nation of just rules of law.